Okay, good morning everyone and welcome to Symptai's webinar on preparing your business for the Data Protection Bill. My name is Daniel Monroe and today we'll briefly discuss the Data Protection Bill itself, and then we'll get into how it affects your business and the suggestions for what you can do right now for some quick wins. Okay, let's get started. The Data Protection Bill. Companies are becoming more digital lately. They feel a need to capture additional data about customers, to be able to, in a more expedient manner, to serve them better, to be able to attend to their needs in a more intuitive manner. So companies have been collecting data, but there haven't been much of a guidance on how we should do it, what's the protocols involved, and things like that. And so this bill seeks to alleviate some of that problems, not just for the customers, but also for companies on how you can access data. These things also protect you, not just the customers. And a few examples of this is, just for some context, you may be sharing your information with a financial institution. Pharmacies, supermarkets are offering rewards and benefits programs and cards, so they're capturing data on you and capturing how you're spending and when you come and spend. Cookies on websites to track your movements, and initially just to get a better understanding of how you're using their you're using company websites, the customer that is. But nowadays cookies have been getting more complicated and some are behaving like applications, and so collecting data has become very integrated into the daily activities of a company, and so this bill will help with addressing some of that. But point to note is that while you may be collecting data from customers directly, you may also be collecting data from other companies. Companies share data at the moment. An example of that would be the Chamber of Commerce for a parish or a city. They may have a mailing list and they may share it with their members and other companies that register with them. And so, customers' data can move around a lot, and the customer may not be aware of some of these movements and some of the activities that's going on with their data. And just before we get really into it, I want to go through some key terms. First up, personal identifiable information, also called personal data in the bill. This is any information that can name or identify the person uniquely. And a step up from that information is sensitive personal data. This is additional data about a person that is sensitive in nature, medical information. If you are a health insurance company, you may be collecting blood type, collecting blood samples themselves to then be able to process the insurance or something like that. The Information Commissioner, this is a role appointed by the Data Protection Bill. It's already been filled. The role is in place right now. The act is not yet in place for him to have powers as yet, but once the bill is gazetted, it officially becomes an act, and then companies will have a 2-year period to prepare themselves to meet the requirements and the guidelines set out inside the bill. And companies can be basically split into 2 categories. That's data controller, also called the data custodian. They determine the purpose for which and the manner in which personal data is processed, how it's stored, how it's used, and things like that. Whereas a data processor is getting instructions from a data controller on how to handle, how to treat, how to process this data. So a relationship you can imagine is a company, a store, possibly online. They have their website using Squarespace, and they have their database in Amazon Web Services or Azure, Microsoft Azure. Azure or Amazon Web Services would be like a processor on behalf of the company that is the face. They're the ones really collecting the data. It's just being stored and possibly being processed on by AWS. And now the data subject is any named person or identifiable person. So the PII, personal identifiable information, will identify the data subject. Okay, and the Act has 8 main components. They're the standards or principles that govern the Act. And many of these are the first 4 of the 8. Many of these you will be familiar with already, like fair and lawful processing, obtained for specified and lawful purposes, or purpose limitation, as some person might call it. Data is accurate and up to date. But 3, I want to just point out adequate. This means that the amount of data is sufficient to support the process or the service that you're offering. Not less, and then you have an issue providing service, and not more, where it may be seen as excessive collection of data. And here are the remaining 4. Standard 5 is kind of a 2-for-1, where they mention data retention is limited to the purpose, and of course, to dispose of that data once it's no longer required. And this may be a little tricky for some companies, especially banks, where they may be required to keep data, I believe, for 7 years. I think it's recommended to keep the data, retain data for 7 years after the last interaction or transaction with the customer, if the services and accounts are closed, in case of investigations for fraud, any other investigations really, and to support anti-money laundering and proceeds of crime, KYC, know your customer requirements and so on. Data is processed in accordance with the data subject's rights. Data is secure, so that's number 7. And you may already be familiar with securing your data, because a lot of companies have been working to move into to digitally transform their company, and seeing that data is an asset that they can utilize to learn more about their customer and their business and how customers are using it. So data needs to be secure to not just protect the customer, but also your proprietary logic and uses of the data. But number 8, you may not be familiar with. It's relation to adequacy. This is limiting the sharing of data to other countries or entities outside of Jamaica, without permission, of course, that do not have the requisite level of privacy and protection protocol in that country or even within that company. And an example of this may be, going back to banks, correspondent banks. So you travel abroad to, you use your credit card and the stores that you go to, or you do some shopping online. The store doesn't have an account with the local bank, so the information gets transferred through the local bank for the business entity that you go to. So for example, Amazon.com goes to their bank. They find out who the correspondent bank is for example, your local bank institution, and then some amount of data is transferred between the two to say, yes, this is a legitimate card, it has sufficient funds, and so on. So there is some transferring between the countries of data. So data adequacy and limiting the sharing will not necessarily put a hamper on correspondent banking, but in a sense where you are transferring data outside of the country into some other entity, there will be some new guidelines and limitations on that. And just to briefly highlight the rights of the data subject, many of these, just like the standards you may have heard already, access to personal data, and to be able to get that in an intelligible format, whether physical or digital, the ability to transfer their data to another data controller. They can request how their data is being processed, if any automated decision taking is occurring, they have a right to rectify any inaccuracies. So if you have an outdated address on the customer, any invalid information, they have a right to request that it be updated in your system and it be done within a specified time frame. Just want to point out that the Act differentiates between consent to general processing and consent to direct marketing. Where consent to processing is filling out an application form and you have a consent page that says we collect this information for these purposes, we process it in these ways, provide services and support you as our customer. Consent to direct marketing will have to gain consent from the customer to directly interact with them electronically or physically, electronically more likely, and use their data for that direct marketing effort. So the consent for that will have to be different for the any other processing that you may be doing. And the bill stipulates some sort of governance structure. And as I mentioned, they have already implemented a information commissioner based on what the Act has outlined. And that commissioner will report to a data protection oversight committee. The committee hasn't been assigned yet, but it should be before the bill is, or the Act is fully enacted after the 2-year period. And the information commissioner will have some powers given to him from the Act. They can even issue warrants for inspection and seizure if they deem necessary to be able to investigate an issue. And business entities will have to register with the Information Commissioner's office to let them know that they are collecting data, that they are processing data, and there are fines in place if you do not register on your phone to be processing and collecting information. I believe the Act states that it's not exceeding 1 million Jamaica. And just want to point out that the customer does have some ability to interact with the information commissioner in the event that they need to make a complaint, if they need to appeal an issue that they are having with the business entity. And just want to also point out that though this Act seems very strict and limits your ability to do a lot of things, you may be wondering, but what about AML, KYC, POCA? If there are any other industry regulations, almost all privacy bills, not just in Jamaica, GDPR, ones in the US and the other Caribbean countries, they do not supersede existing regulations. And there are many clauses inside Jamaica's bill where they mention about being able to respond to national security issues without getting consent from the customer and so on. So other industry regulations will not be or should not be hampered by the Data Protection Act. But why data privacy now? And as I mentioned earlier, using data as an asset is getting very popular. Some companies are collecting excessive amount of data, and the governments are realizing that there needs to be some control for the customer so that they can have some say about what happens to their data. And in terms of Jamaica, we signed some agreements with CARIFORUM, that's some of the other Caribbean countries, as well as the Economic Partnership Agreement with the EU, which stipulates that we need to have some adequacy in place for EU companies to be able to do business with Jamaica. They need to ensure that Jamaica has sufficient protections for data privacy, just like what they do, or at least close, very close. And it works for us as well that we can demand data protections for our data with anybody that we're doing business with outside of our country. And of course, provide the governance structure that was just mentioned to protect the data and the individual's rights. And just to highlight some trends here, more countries are implementing their own privacy regulations as mentioned. In the Caribbean alone, Cayman, Barbados, Bahamas, Turks and Caicos are a few that already have it. enacted and implemented, St. Lucia as well. And if you're doing business with these countries, you have to be complying with their data privacy acts. Transparency of your privacy initiatives, because providing services that take privacy into consideration is now a differentiator between services that companies are offering. It is a selling point for many persons, for many companies, and helps you to prepare for compliance. Data privacy won't really work without protections in place, and so data privacy has to work very closely with data security and other IT departments, such as networking and database management, to ensure that the protection aspect of data privacy can be properly implemented. A lot of companies are also implementing privacy by design. This is a life cycle or paradigm where new and existing products for services, for processes, they are being designed from the get-go with privacy. Or if it's an existing product, then they're being reviewed. A privacy impact assessment may be done, and it might identify the issues with that existing service, and then you make the adjustments necessary to bring that product or service or even process up to scratch with the privacy requirements necessary. And of course, companies are tracking new privacy laws, the standards and guidelines that are coming out after the laws are being enacted as a part of their risk management. As I mentioned, there are many Caribbean countries in place right now with their own laws, but you may be storing your data in the US. Currently, almost every state has their own privacy laws. Some are not as strong as others. Some are just a clause inside another act. California is one of the strictest ones. And there's a big push because of all the competing laws in the US to consolidate and have one federal law. So you need to be able to keep an eye on that and ensure that we can manage our risks that may come out of that new law that may affect us, since the United States is usually a big contributor to our economy in terms of business. And third-party risk management. Your relationship between yourself as a data controller and your data processor, it will have something similar to adequacy requirements, where it's not just you need to make sure that the country you're sending your data to has protections in place, but you also need to look at the persons that you're doing business with, the persons that you're sharing data with, vendors that you are hiring to program, to the marketing, to assist you in any way. If they have access to your data, you need to ensure that their company and the securities that they have in place is sufficient to provide security for your data while it's in their hands. So that's a big trend that's going on right now. And just to quickly highlight that GDPR has been very active over the years, and they have been fining many companies, and some have appealed and been successful to reduce the fine, but some have not. Just to point out, Marriott, they acquired a hotel that was closed for years, and an investigation was done after they had acquired this new company, and it was found that the company that they acquired had no security in place, the data was exposed and things like that. So the Marriott ended up being fined for this. They didn't do a sufficient investigation in the data that the company that they acquired. So they ended up with some issues with the EU. Just a note, EU is one of the strictest ones in terms of fines. It is 4% of your gross annual, or 20 million euros, whichever one is higher. Jamaica is not so exorbitant. I believe the act says that it's up to 2 million, but our act also includes that there may also be prison sentence along with the fine, depending on the situation. Okay, some questions are coming in. That's great. Send your questions in the comments, and we'll have a Q&A section towards the end where we will try to address as many of these questions as possible. So please send in your questions and let's discuss. All right, so now to the main part of our recommendations: preparing your business for data privacy and protection. For the first thing, we are recommending that you perform or conduct a privacy health check. You need to understand everything about your data as much as possible. You need to get really intimate with it. So you need to know what data is being collected about your customers. And these are, when I say customers, I don't just mean persons coming into your business to acquire a service or a product or so on. These are also your internal customers, your employees and staff. Hiring persons, you do collect a lot of information. You may even do background checks that the person may not even be aware of, or you do get permission from it to conduct a background check, and then you have all this information about a person that is not working for you. So it's not just external customers, it's about your internal customers as well. What data is being collected? Where is it being collected and stored? Are you collecting it only in store, in your front-facing stores, or are you going out into public, into events and collecting information? Are you collecting it on paper? Is it only in your core system? Are you using some sort of third-party application that interfaces or doesn't to collect data about persons? How is your data being processed? You need to understand whether it's just core system processing for applications and so on. Are you doing marketing analysis or some other business intelligence analysis to learn more about your customer and their behaviors? Are you doing assessments on customer to score and rank them, to segment them and things like that? Are you doing it yourself, or are you using a third party to do that? Who has access to your data? Of course, many persons have segmented roles in their systems already, so not many persons outside of particular role functions will be able to see everything, and even then there may be some issues to see all the data. But are there other roles in your company where persons have super users or anything like that? Are you able to see everything that's on the file server, or are you restricted to folders that your department uses? Do you have vendor users in place, and are you leaving them up and available? You haven't closed down that user or deleted it from your system after the engagement with the vendor is over. Which countries do you operate in or have customers in? Just as I mentioned before, regulations are coming up almost everywhere. So you need to understand where you're doing business, and in the terms of EU and a few others, you need to be aware of where your customers are from. The GDPR, that's the General Data Protection Regulation from the EU, they don't just say that if you're doing business within the EU, it's also about having data on EU citizens. So once you have data on these persons, you may know be liable to their data protection laws. And then find out what other regulations are affecting your business. If you have health information and you're storing your data in the US, will HIPAA, that's the Health Industry Protection Act, does that apply to your business? No. Finding out what other regulations are in place, if there are additional AML requirements because you're working with this other country, or so on. How do they affect your data and your ability to use and process this data? And this might be one of the a little more tedious, is because lots of large companies have hundreds of application forms in place. Some persons may have thousands of contracts in place, but you will need to review your current contracts and the current application forms for what kind of data you're collecting, and where you're storing these paper forms, filled out paper forms, and understand if you are collecting consent in the application process, in the contract process, and data sharing clauses are more robust. I know a lot of persons right now may have a clause specific to the Credit Bureau Act in Jamaica, and so you may have a page that says we share some of your data with one of the credit bureau agencies or both, to be able to get a credit scoring and to be able to use that to guide or assessment of your application for purchasing this piece of furniture. And but you may not have any other documentation or any statements in there that say, we collect this data for other processing, for other purposes, not just to share with the credit bureau. We also share this with subsidiaries of our company. We're a group of companies, so there are several other entities that we may share data with, who we may do business with, and so on. So your consent components of your application forms and the data sharing clauses involved will need to be revamped to ensure that you are in line with the stipulations of the Act. So once you've done your privacy health check and you understand where you are, what you have, what you're doing with it, and who you have it for and who you're doing this with, you can design a roadmap to guide your company on the next steps for completely satisfying the guidelines that will affect you and your operations and your ability to collect and utilize data. And we recommend doing an internal education and awareness campaign. You need to get buy-in from your executive stakeholders as soon as possible. If they're not aware of data privacy, you need to ensure that they're aware of it right now and what it means for your business. Get buy-in, because they're the ones that are going to sign off on allowing getting the next tools that are involved to support the privacy function and so on. Understand the laws, not just identify them, but understand them. Once you've identified them, you already have customers and so on, and let the executives and other key persons in your organization know and understand this, so that when you're creating your roadmap, you can be aware of these things that may affect and alter any typical activities that others may be taking to satisfy the guidelines. And sensitize your staff about the data protection bill. You don't want to blindside them with new processes or changes to the process, at the end of your activities of revamping your process and so on. You don't want to surprise them with it. You want them to be able to be on board as well, to adopt it and to promote it, not just to other staff members, but to your customers, the benefits of data privacy and what you are doing about data privacy in your company. And of course, get key personnel trained and certified. Some acts require that persons who are responsible for data privacy be certified. Currently, there are 2 organizations that are providing certification, and that's the International Association of Privacy Professionals, who Symptai is partnered with, and of course the ISACA. These are, but that certification is more for auditors, whereas the IAPP certifications are for frontline professionals. You can technical persons for the management of privacy and so on. So there are various privacy programs out there that you can get trained and certified in, and you should do that as soon as possible for your key persons, especially the ones who will be implementing any privacy initiatives within your company. And build a data privacy team. All laws require that the company have a data privacy officer. Some regulations require that you have a representative within that company if your head office is not in that company, but you do have an office within their territory. So you may not have to have multiple data privacy officers, excuse me, but you may have to have additional representatives in other countries depending on how big and your company or your group of companies are. And as you can imagine, this is going to be a lot of changes for your company. So the data privacy officer won't be able to do it by himself. He's going to need support. So you may need to include privacy officers and analysts. Auditing will be a major part of the local Data Protection Act, because you may need to prove that you are providing sufficient support and meeting the regulations and the guidelines sufficiently. And you can't do that. You shouldn't do that yourself, of course. Like any other compliance, you should have a compliance team or audit team that can objectively look at what you're doing and share a report with the Information Commissioner if they should request it. This is a law, so getting legal involved early is important to ensure that you understand your obligations under the law specifically, and the language that you should use for your consent forms, your sharing clauses, and things like that. And as we mentioned earlier, data protection, it relies heavily on security, on network, and your other IT functions. So you should have a representative from these teams to support your privacy team, support your data privacy officer. And of course, if you have multiple lines of, well, any amount of lines of business, with a representative, a subject matter expert from that line of business to be able to assist, or a point person that the privacy team can interact with to understand exactly how that business function is operating, so that they can make the changes to the processes effectively. And of course, human resources. You need to communicate with all your staff. You need to update job descriptions, especially for like a data privacy officer or privacy analysts and things like that. You may need to nominate somebody that's already within your company as a privacy officer or a data privacy officer, or you may need to go out and start a hiring process. So HR will be very integral in the building your team sufficiently. Okay, those are the three main things we recommend to do right now. The additional item would be to develop a roadmap that will guide your company in the next steps after you have done these items. So find out what things are critical, the higher risk items that need to be addressed right now once you've done these three, and then you continue to build out a roadmap, build out the initiatives that you are undertaking to meet the privacy requirements once they become enacted within approximately 2 years. All right, so now we will open up for Q&A. Yeah, so we are actually having a privacy training seminar at the end of this month. That is July 28 to 29. And we have an early bird going on until July 17th. This is for CIPM, Certified Privacy Manager. This is to help you get ready to understand what the regulations are and how you can manage your entity, your company, for privacy. And you can register online at the link provided below. That's symptai.com/training-courses/CIPM. Or you can get in contact with us directly with Mechanics or Andre Palmer or Larissa Babalal. Is there any other information that one of the panelists would like to add about the training?
Yeah, hey there. Byron Johnson here from the IAPP.
Hi,
just
Byron.
on this Symptai webinar to provide some background on the IAPP, and then also some information on the CIPM certification. For those who don't know us, the IAPP, or the International Association of Privacy Professionals, we're a global member-based organization established back in 2000. We really view and conduct ourselves as the big tent for privacy globally. We're a great group of people who are just trying to kind of spread the good word of privacy, both protecting ourselves, our employees, our businesses, our grandparents. There's data everywhere, and unfortunately, right now in this data economy, there's a lot of issues that could come up when privacy and the protection of personally identifiable information isn't taken care of. So the IAPP really does its best to research, train, and educate, be that place for discussion. We hold conferences. We have 8 publications that go out weekly. These are all resources for you that you receive when you attend one of our courses through a training partner like ours, Symptai. So Symptai is the only certified training partner of the IAPP in English-speaking Caribbean. They were really the gold standard for us to match with to offer the Certified Information Privacy Manager certification, as well as the Technologist certification. These are pretty much set up to, even if you're new to privacy, or this is a role for a lot that has kind of gotten flopped on their desk and now they take care of it. This is really going to help you successfully operationalize privacy. It's going to help you turn a business risk into a business advantage, like Daniel was talking about. You're going to learn how to adopt and develop a lasting privacy program. Tanya was asking, how to choose a framework. That will actually be covered in this training, and really does help give you a view of privacy that could help make you a champion, what we like to call, a privacy practitioner in an organization who's kind of taking it on to educate themselves in privacy, but also help their whole company adopt a privacy program that'll be successful. Adding that privacy program to your company can help you attract top talent, allow you to work with other companies, for example, vendors or third parties like Daniel was talking about, because you're a safe place for data, you're trusted, your reputation is attached to that, especially if you stay out of the news due to a data breach. But the certification really, from a personal standpoint, can get you to a better place in your career where you could become a little bit more valuable in your space, but also take on some of this new opportunity that the data economy has given us, which allows you to be, a respected member of your organization and help protect the data of your customers, employees, etc. Symptai's course on the 28th and 29th, just to go over a couple things here, will also include creating a company vision, for example, structuring a successful, lasting privacy team. You really do, like Daniel was saying, you really do want to be walking across the hall and talking to legal, talking to IT. Unfortunately, no longer there's a separation between security and privacy. You really do have to, walk across the hall and talk to the tech guys. These certifications will give you the lingua franca, or the language to talk to each other and really build a privacy program that can help you grow your business in the data economy and become successful going forward. Back to you, Daniel.
Thanks, Baron.
Yeah, no problem.
All right, we have a few more minutes. Andre, is there anything else you want to add about the training?
Well, Byron pretty much went through quite a bit of the content. So just to reiterate that there is an early bird pricing that runs until the 17th of July at $2,100, which also includes the voucher for the exam, as well as access for a year to the IAPP's community as well. So I'm happy to field questions. My email address is up there, so is Larissa's, as well as both our telephone numbers. So, the participants can get in touch if there are additional questions.
All right, thank you. It's 11 o'clock. Thank you everyone for joining us today. I hope we were able to highlight and illuminate some issues with some questions with the Data Privacy Act, and we hope to hear from you soon for this privacy training to get your key persons up to track, and look forward to working with you in the future. Thank you.